morning. I call this hearing of the Minnesota Senate Select Subcommittee on Federal Impacts on Minnesotans and Economic Stability to order. It is 10:04 on Thursday, January 29th. I'm Senator Lindsay Port, the chair of this committee. I want to start with a few housekeeping items and a welcome to some guests we have joining us today. First, this hearing is scheduled until 1 p.m., as has been publicly posted. We have a large number of testifiers today and ask those testifiers to try to keep to the time that you've been allotted. Members, please get Ms. Carlson's attention as soon as you know you want to speak so that we can keep a list and keep our member comments moving, and try to keep your remarks concise and on topic. Because of the full room today and the difficult stories that we'll be hearing, I ask that you please take side conversations out into the hallway. Joining us today are lawmakers from across the nation who have traveled to Minnesota to listen to, learn from, and support our communities. There are 13 states represented in this room today, including Wisconsin, Montana, Utah, Colorado, Illinois, Rhode Island, Georgia, Michigan, Missouri, North Dakota, North Carolina, Oregon, and Tennessee. Thank you for joining us. Unfortunately, we don't applaud during hearings, but a sincere gratitude to those lawmakers who have worked with us on many different pieces and will continue to work together. We appreciate your support today. I am going to turn it to the ranking member of the committee, Senator Carla Nelson, for some opening comments.
Thank you, Madam Chair. I appreciate the opportunity to be here. And I also want to thank all the committee members and our guests. As you know, as we all painfully know, this meeting comes at a tough time, and Minnesotans are facing challenging times. Our current atmosphere is charged, and in moments like this, our responsibility as leaders is to steady things, to not inflame them, and our fundamental goals are simple. Protect Minnesotans, uphold the law, and preserve our constitutional rights. Unfortunately, tragic events have shown us what happens when communication breaks down, and when local and federal authorities stop talking, when protesters and law enforcement view each other as enemies or evil monsters. That's when things get very difficult, very difficult. And I welcome the fact that we seem to be, I hope we are entering a new phase. The recent shift in tone from President Trump and Governor Walz is a good thing. I hope it leads to positive outcomes because we desperately need a reset and a recommit to cooperation. I would just say that again. It is so important. We desperately need a reset and a recommit to cooperation. Removing violent, criminal, undocumented immigrants is a reasonable and necessary step to keep our communities safe. But at the same time, chaos and confrontation helps no one. People have the right to protest, but they do not have the right to obstruct law enforcement as they enforce the law. Or do they have the right to put lives at risk? Confrontation only raises danger for everyone. Finally, I would just conclude by noting that this subcommittee exists to deal with federal impacts in a serious and grounded way. And I hope that is the tone that we can set today. Madam Chair, I thank you for the time and look forward to hearing from our testifiers and the rest of the committee. Thank you.
Thank you, Senator Nelson. Senator Rasmussen?
Thank you, Madam Chair, and I appreciate the opportunity to provide some opening comments before we hear from our testifiers today. I think everyone in this committee would agree that Minnesota's had a very challenging 12 months. I want to make clear that we need to protect the constitutional rights of Minnesotans and enforce our nation's laws. We can and must do both. I'm glad that President Trump has sent his border czar, Tom Homan, to Minnesota to have conversations with Governor Walz and local officials on how we can improve the current situation in Minnesota. Tom Homan has served in key immigration leadership roles under multiple presidents, including President Barack Obama. In fact, President Obama awarded Mr. Homan the Presidential Rank Award for his work in immigration enforcement. Earlier today, Mr. Homan stated that he expects a decrease in federal officers in Minnesota based on common sense cooperation between state, local, and federal authorities. Minnesota needs Governor Walz, Mayor Fry, and other officials to work in good faith to de-escalate the situation here in Minnesota. Federal immigration officials would prefer to arrest criminal illegal immigrants from state prisons and local jails versus on the streets due to a lack of cooperation. Unfortunately, we've seen Minnesota Democrats advocate for sanctuary policies that prohibit cooperation with immigration authorities. Let me be clear on what that means. When a violent criminal illegal alien is arrested by local law enforcement and is in a local jail, immigration authorities can request that the individual be released to their custody. Some of the largest counties in Minnesota are currently refusing to honor these requests and are instead putting violent criminals back on the street. These sanctuary policies make Minnesota less safe and should be rejected. And those are proposals that we can consider as a part of the upcoming legislative session, and I would encourage further cooperation and dialogue during this important time for our state.
Senator McQuaid.
Well, thank you, Madam Chair, and I want to thank everybody who has joined us today and who is watching virtually, who is here to share their testimony, and those who can't be here to share their testimony because it wouldn't be safe. I was distracted a minute ago because in my community, ICE is going door to door, knocking on doors, looking for people of color and asking for their papers. We have seen this over and over and over again. There are Native Americans, indigenous Minnesotans who are still being held. There are children, babies, who have been taken from the streets and sent to God knows where. This has never been about cooperation. The Cottonwood County Sheriff, Deep Red Cottonwood County, has described trying to release an inmate who served their sentence to ICE, and they said, sorry, we're too busy hunting down the people in the Twin Cities. This has never been about lack of cooperation. Minnesota law enforcement, counties, jails, and prisons have always complied with the state law that requires them to. What has happened is Black, brown, Asian, and indigenous Minnesotans have been harassed. The white neighbors and allies who stand up for them brutalized, murdered, assaulted, all because we care and love for one another. Because a paramilitary has invaded the state with money that they took from our health care and our food assistance to terrorize our state. We are not broken. We are not tired. We will stand in the gap forever for our neighbors. But this must end. And then we must repair. And that will require deep accountability. It will require truth-telling. And it will require people to understand that telling the truth about what happened is not rhetoric and is not inflaming things. Naming what has happened is not rhetoric and not inflammation. What has happened is terrible. What has happened should never happen in any state, Minnesota or any other. We are not looking for ICE to just leave Minnesota. We need them to leave and never bring this to another state. Minnesotans will not put this on any other state in this country. We are at an inflection point. And I want to say that I'm hopeful about what I heard today, but I can tell you that what was said today about a drawdown or reduction in troops is not what's happening in my community. Bus stops are being terrorized. Schools are being terrorized. The number of notifications that have to go out from my school district to parents about the number of ICE cars on premise is obscene. Parents sit in daycare parking lots to make sure that their children and their teachers are protected. United States citizens carry their passports, hoping that they don't get accosted on their way to a donut shop, and hope that the person who takes it will take it seriously and let them go. And that hasn't always happened. My composure is wafer thin. I get up at 6 in the morning to listen to stories of parents who are too scared to leave their house. I go to bed at midnight trying to find legal assistance for US citizens who've been detained. What is happening here is almost indescribable. In fact, we are under-describing it. And I'll just end because I don't want to break down at the beginning of a committee hearing. But I cannot believe what we have seen. I cannot believe what we are experiencing. And Minnesotans, regardless of party, place, gender, race, are standing up and saying, hey, no. So today we are Minnesotans. We're going to put down all of the party affiliations or all of the talking points that we've been given by any one person. We are Minnesotans today. And we are going to listen to the stories of Minnesotans. And we are going to begin, hopefully, when this ends, because it is not, to repair and get accountability. Thank you.
As we move to the testifiers on our hearing, I want to begin this hearing by bringing us together for a moment of silence to mark the deaths of Renee Macklin-Good and Alex Preddy, two beloved and brave Minnesotans taken from their families, friends, and neighbors far too soon. Please join me in a moment of silence. Thank you. The violent deaths of Alex Preddy and Renee Macklin-Good brought the world to a halt. Other tragedies unseen, but no less painful, no less wrong. Victor Manuel Diaz came to Minnesota in 2024 from Nicaragua, a poverty-stricken dictatorship, to make money for his two sons and his mother. Victor found work on a dairy farm, then recently in the kitchen at a Coon Rapids restaurant that was raided by ICE on January 6th. Victor was taken to the East Montana Detention Center in Texas, a tent city of 2,700 people who have reported medical neglect, hunger, physical, psychological, and sexual abuse. On January 14th, Victor Manuel Diaz died. He was 36. The Department of Homeland Security says Victor's death was a suicide. His family doesn't believe it, and who can blame them? This administration says they came to Minnesota to arrest the worst of the worst, and we've seen what that means to them. Young children, elderly women, line cooks, people at bus stops, in line at the pharmacy, at their immigration check-ins, driving to work, or hiding in their homes. Donald Trump expected Americans to give up their neighbors, but he came to the wrong place. The Minnesota response to ICE's occupation is an inspiration. Community organizing, street monitoring, protests and vigils, people donating time and money, delivering food and medications, carpooling, school kids, and workmates. This invasion has met an insurgency. And that insurgency is healthcare workers and teachers with a moral code, union members with cell phones and whistles, PTA moms with minivans, and grandmas with Costco accounts. In 19 days, when the legislature comes into session, resistance means leadership, reclaiming our sovereignty, inscribing rights that belong to Minnesotans and all Americans, and demanding accountability for the agents who perpetrated this evil and the leaders who sent them here. Today, resistance takes the form of documentation, documenting the truth and bearing witness, building a body of evidence for investigators and prosecutors, elected leaders, and future generations of Americans as we decide what we can tolerate and what kind of country we want to be. Today and every day, we're building a roadmap to navigate through authoritarianism, a path forward to a future that values humanity and the rule of law. This hearing is a document to the American people and the world to know that this cannot happen to a peaceful people, and when it does, we will fight back. We'll start today with a constitutional analysis of the ICE actions of the past few months. Will Mr. Bowler, Ms. Nelson, and Ms. Decker please approach the testimony table? Please introduce yourselves with your full names, and when you're ready, begin your testimony. Senator Rasmussen?
Thank you, Madam Chair. While our testifiers get ready, do you know, Madam Chair, do we have anyone from the Department of Public Safety here today that, if we have questions based off the testimony, would be able to answer any questions?
We do not. We did speak with them. They are engaged in the work in our communities at this moment.
Thank you, Madam Chair. I just think it would be, it's my understanding that Governor Walz has designated the Department of Public Safety to have these ongoing conversations with Mr. Holman and federal authorities. And so if they're able to join us at some point today, I think that could be helpful to see the latest on their conversations. Thank you.
Please go ahead and introduce yourselves for the record and begin your testimony whenever you're ready.
Good morning, Chair Port and members of the committee. Morning, Chair Port and members of the committee. My name is John Beeler, and I'm the Policy Counsel for the American Civil Liberties Union of Minnesota. I have with me Teresa Nelson, the Legal Director for the ACLU of Minnesota. Thank you for the opportunity to speak with you today. What we have witnessed in the last 2 months, and what we are continuing to witness, is one of the largest deprivations of constitutional protections in the history of our state. Largest here includes the number of constitutional protections violated and the sheer volume of violations by federal officers. By way of background on how we arrived here in these circumstances, in December 2025, the Department of Homeland Security announced the beginning of Operation Metro Surge, which included the deployment of 3,000 agents, including 2,000 from Immigrations and Customs Enforcement, or ICE, and 1,000 from Customs and Border Protection, or CBP, which ICE Director Todd Lyons called the largest immigration operation ever. And this was, lest we forget, ostensibly a supplemental fraud investigation. These actions have resulted in the deaths of multiple Minnesotans, including the shooting deaths of Renee Good and Alex Preddy, and the custodial death of Victor Manuel Diaz. These actions have caused untold damage to our residents through direct physical assault, liberal deployment of chemical irritants like tear gas and pepper spray, and countless restraints and arrests. It has caused untold trauma through unlawful arrests and detentions, family separations, and families forced into hiding regardless of citizenship status and solely based on race and ethnicity. I want to stress the adjectives I used in those previous statements. Untold, countless, it's like that. One of the hardest aspects of our work now is to accurately quantify the breadth of the harm. We do not know how many Minnesota residents have been deported, detained, arrested, injured, or violated. We do not know how many Minnesotans are currently in detention, where they are being held, and whether they have legal status that would prohibit their ongoing detention. This is a direct result of the disinformation and complete lack of transparency by the federal government. According to DHS last week, they say they have arrested 10,000 immigrants with criminal records. We have no reason to believe that number is accurate, as no comprehensive list of names, records, immigration status, criminal history, or present detention status has been provided. By way of example of this information discrepancy, DHS claims that there are 1,360 individuals with ICE detainers in Minnesota custody. According to a survey of the Department of Corrections records, there are 207 individuals in state custody and another 97 in county custody, resulting in a difference of nearly 1,000 individuals. We do, however, have some numbers available. Since the opening of our reporting portal 6 weeks ago, the ACLU of Minnesota has received over 500 reports of constitutional violations by federal agents. This is obviously only a small sliver of actual incidents because it does not include those where individuals do not know about our reporting form, where they are afraid of retaliation for making contact, or due to the nature of their detention, there is no one available to file a report on their behalf. In a rather remarkable order yesterday, Judge Schultz, Chief Judge of the United States District Court of Minnesota, said the ICE has violated 96 orders across 74 cases just this month and just here in Minnesota. He said that ICE has likely violated more court orders in Minnesota in January 26 than some federal agencies have in their entire existence. The ACLU of Minnesota has 2 cases in federal court stemming from the government's actions these past 2 months. Tincher v. Nome is a case involving violations of the First Amendment rights of individuals to document and protest ICE activity and their Fourth Amendment rights to be free from unreasonable seizures and excessive force. On January 26, Judge Menendez of the United States District Court of Minnesota entered a preliminary injunction that plaintiffs were likely to succeed on the merits of their claims. That injunction, however, has been stayed by the Eighth Circuit pending appeal. In Hussein v. Nome, we are seeking a preliminary injunction prohibiting federal agents from their unconstitutional practices of making unlawful warrantless arrests and of stopping, questioning, and detaining Minnesotans on the basis of race and ethnicity. That case, filed 2 weeks ago, is set for a hearing on February 9th on our motion for a preliminary injunction. There are numerous other cases brought by attorneys primarily seeking writs of habeas corpus to compel the release of wrongfully held Minnesotans, and as we'll discuss later, the courts have been inundated with these cases due to rampant wrongful detention and violations of court orders. Now, when we think of constitutional protections, we generally think of the Bill of Rights, the first 10 amendments to the Constitution. We have violations or threats to violate 6 of those amendments in less than 2 months. Threatening to violate constitutional rights is in itself a violation of those rights because of the chilling effect it has on people's ability to utilize those rights. I'll just run through a quick list for you. The First Amendment explicitly protects several freedoms, including freedom of speech, freedom of religion, freedom of the press, and freedom of assembly. Courts have also long read into the First Amendment a right to freedom of association. The First Amendment right to freedom of speech includes the right to peacefully document law enforcement officers engaged in their official duties. And as the court in Tincher noted, that is true of every circuit court to have considered the question. Yet, when our client Susan Tincher was observing ICE conduct and asking if agents were here with ICE in Minneapolis, she was pulled to the ground, handcuffed, removed to the federal Whipple building where agents removed her clothes and cut off her wedding ring. She was released after 5 hours in custody. Our client, Abdikadir Noor, observed ICE detaining 2 Latino men and another woman attempting to inform the men of their right not to answer questions. The woman was thrown to the ground and held there face down in the snow for nearly 30 minutes, while agents broke the window of the vehicle and dragged the 2 men out of their car. Then the agents turned their focus to Mr. Noor, who was grabbed, forced to the ground, handcuffed, driven to Whipple, while at Whipple, Mr. Noor was subjected to racist commentary from the officers, shackled, and eventually released without charges or documentation. This case alone contains over a dozen instances with sworn statements of Minnesotans exercising their First Amendment rights who were subjected to federal harassment, violence, and detention. Federal agents have violated the rights of the press. Earlier this week, ICE agents threatened to break the window and detain 2 Italian journalists who were recording ICE activity. Last week, the DOJ sought an arrest warrant for journalist Don Lemon for covering a protest, which was denied by the federal magistrate judge. The DOJ asked District Judge Schultz to review the denial, something that the judge said neither he nor his colleagues collectively had ever heard of. Not only that, when the DOJ did not like the time frame in which the judge informed them he would make his decision, they appealed over his head to the Eighth Circuit, where their petition was denied. On freedom of association, earlier this week, FBI Director Kash Patel threatened an investigation into text groups that Minnesotans are using to notify their neighbors of ICE activities, to coordinate rent and food relief, and to alert their school and daycare workers of federal raids. On the Second Amendment, after the killing of Alex Preddy, FBI Director Patel said that Americans, quote, cannot bring a firearm to any sort of protest you want. Similarly, President Trump said, quote, you cannot have guns. You cannot walk in with guns, in response to the incident. All Americans, including gun owners, have First Amendment rights. And while gun ownership is a separate constitutional right and gun use itself is considered conduct outside the First Amendment, gun owners do have equally strong core First Amendment rights to speech and protest. The government cannot treat lawfully armed speakers more harshly simply because of their views or because they are lawfully carrying firearms. On the Fourth Amendment, the Fourth Amendment bars the government from unreasonable search and seizure of an individual or their private property. In our litigation, Hussein v. Nome, we identified numerous stops made by federal agents solely on racial and ethnic appearance of those detained. Our clients, like Mr. Hussein, who were physically restrained and dragged to a squad car, declarants, like Mr. Saki, who needed hospitalization, and AA, who was handcuffed and forced into a squad car. Rarely, if ever, do federal agents meet the requirements necessary for these stops. Probable cause to believe a person is removable and that they are a flight risk. Rarely even do the agents know who they have stopped, but rather they are making a stop on the basis of race and ethnicity and then proceeding from there. Last week, law enforcement officers from around the metro held a remarkable press conference saying they have received endless complaints about federal agents profiling these residents, including federal agents racially profiling off-duty Minnesota law enforcement officers. One officer from Brooklyn Park was assaulted when she attempted to record the encounter. On the Fifth Amendment, the Fifth Amendment requires due process before the government deprives someone of life, liberty, or property. The Due Process Clause protects individuals from government action where it is motivated by animus based on race, ethnicity, national origin, or religion. The right to equal protection, explicitly set forth as applying to the states in the 14th Amendment, is applied to the federal government through the Due Process Clause of the Fifth Amendment. These constitutional protections are designed to protect against the exact sorts of stops outlined in Hussein v. Noam. These are not just ACLU of Minnesota cases. In fact, these cases are so prevalent that Judge Schultz, again Chief Judge of the U.S. District Court of Minnesota, issued an order earlier this week noting that the federal government had ignored his order to give a detainee a bond hearing or release him within 7 days. The judge noted that this order was, quote, one of dozens of court orders with which respondents have failed to comply in recent weeks, and that the practical consequences of that failure to provide due process means that detainees often spend a significant amount of time in detention, or they are flown to Texas and detained, or they are released in Texas and told to find their own way back to Minnesota. As mentioned earlier, given yesterday's order, we now know that there have been at least 96 orders violated across 74 cases, which the court says is certainly understated. Quick sampling of other findings from district court judges in Minnesota. An individual with refugee status received a fake phone call informing him that he had a package at his door, and when he opened the door, he was thrown to the ground, detained, and arrested without a warrant. No notice has been provided that the U.S. government is moving to terminate his refugee status. A refugee from Myanmar, who's a nursing mother, was separated from her infant child and transferred out of state, an abhorrent action that the court called, quote, particularly craven, and has caused immediate harm to the mother and child by denying them crucial bonding time. The court required the release of a man who was hospitalized with severe head injuries due to the violence of his arrest. Despite being incapacitated with those head injuries, ICE was requiring him to be handcuffed to his hospital bed and supervised by ICE agents at all times. ICE detained a pregnant mother, her husband, and 2 sons, despite active asylum petitions and no criminal convictions. ICE transferred Ms. Gutierrez Montalvan out of state despite a court order directing them not to do so. ICE detained a Ukrainian refugee who fled the Russian war, who has no criminal convictions, and who the government has not sought to remove. The government lured him out of his home by asking him to voluntarily meet with immigration officials and detained him when he complied. One district court judge noted, quote, there has been an undeniable move by the federal government in the past month to defy court orders or at least stretch the legal process to the breaking point in an attempt to deny non-citizens their due process rights. On the Sixth Amendment, which protects the right to counsel, the federal government has been routinely denying immigration attorneys the right to meet with their clients. One attorney was told by federal agents they, quote, don't do attorney visitation. Not immediately, of course, but rather they made him wait 4 hours before informing him of that. These attorneys noted for the last decade, when immigration clients have been held at Whipple, they have been allowed attorney visitation. Attorneys say they have received a variety of explanations for why they cannot see their clients, including claims that they did not have appointments, that their clients did not ask for them by name, and that the Whipple building cannot accommodate attorney-client visits. Another attorney reported that ICE told him, quote, if we let you see your clients, we'd have to let all of our detainees see their attorneys. And imagine the chaos. Imagine the chaos. The Advocates for Human Rights just yesterday filed a lawsuit regarding the refusal of federal agents to allow detainees access to counsel. Their lawsuit says that many detainees are only allowed their first phone call after they have been transferred from Whipple, almost always to an out-of-state facility. Even when detainees are allowed access to counsel, they are not provided with privacy, and federal agents are able to and do listen into their phone calls. The lawsuit alleges that federal agents have pressured their clients to sign forms agreeing to, quote, self-deport without attorney consultation, and that they have subjected the attorneys themselves to physical confrontation and exposure to tear gas. On the 10th Amendment, the state of Minnesota and the cities of Minneapolis and St. Paul have sued the federal government in Minnesota v. Nome, alleging violations of state and local sovereignty as protected by the 10th Amendment. I believe I have already taken up a significant portion of this committee's time, however, and we'll leave it there. Thank you for your time today. We are available for questions.
Thank you, Mr. Bueller. Ms. Decker?
Madam Chair and members, my name is Julia Decker. I am the Policy Director for the Immigrant Law Center of Minnesota, or ILCM. ILCM is a nonprofit, nonpartisan 501c3 organization that provides free immigration legal services to low-income immigrants and refugees across the state of Minnesota. The current crisis we are experiencing is occurring in the context of major immigration law and policy shifts at the federal level that are requiring monthly, weekly, and sometimes even daily updates to the ways that we advise and educate our clients and the community. Immigrants and refugees, including those with lawful status and those applying for lawful status, have been subject to over a year of increasingly hostile and restrictive immigration policies and rhetoric from the federal government. This current crisis that we're experiencing is also occurring, as you have heard, in a moment of extremely low transparency. We're grateful to our colleagues at the ACLU of Minnesota and other organizations that are bringing these cases in federal court to shine some light on what is happening, because the reality of the immigration system, particularly the enforcement and removal system, is that it is extremely opaque, and it has become even more so under the current administration. You've heard from my colleague about the examples of racial profiling by federal agents, violent arrests, failure to provide due process, and other constitutional violations. I want to emphasize that we often receive additional reports of other types of these types of violations occurring when we speak with impacted people and community members. But the speed at which current enforcement operations are occurring and the need to prioritize identifying, locating, and contacting people who have been detained often makes following up and fully verifying reports extremely difficult. Moreover, the relative timelines of federal litigation and immigration proceedings create a situation where even if there is a blatant, egregious violation of a person's civil rights that can be remedied in federal court, an impacted person can very well be removed, deported, long before the civil rights case is ultimately resolved. I want to focus the remainder of my testimony on some additional issues regarding access to counsel. First and foremost, it's important to understand that while people in immigration court proceedings have a right to an attorney, that attorney is not provided to them by the government, as it would be in a criminal court proceeding. So if a person is not able to afford an attorney, it is very likely that they will have to proceed in that immigration court proceeding pro se, despite the often life and death implications of that immigration court proceeding. In the current ongoing operation in Minnesota, what we have seen is that people arrested in Minnesota are often not being detained in Minnesota. Even if they have a pending case in the immigration court here in Minnesota, even if they have an attorney representing them here in Minnesota, they are increasingly being sent, often within hours, to detention facilities in Texas, New Mexico, and other states. This creates serious access to counsel issues. First, it can take a very long time for anyone, including a person's attorney if they're represented, to find out where a person has been taken. While there is an online detainee locator run by the federal government, it is not updated in real time and sometimes is not updated at all. Second, many of the detention facilities out of state require payment for detainees to make a phone call. Phone calls to counsel are free, but only if the person has a lawyer and the lawyer sets up an account. And a lawyer can only set up an account if they know where their client is. As you can see, this creates two issues. First, for people who do not have an attorney, in order to contact anyone, they need money. And in order to contact someone for that money, they need money. For those who have an attorney, the attorney needs to know where they are, which loops back to the first problem. Third, even assuming an attorney can make contact with his or her client in detention in another state, there are additional logistical issues, such as communicating on a regular basis and getting client signatures on required court documents. We raise these issues in the context of the immigration system, and we want to emphasize the extreme harm that has been and continues to be inflicted on Minnesota's immigrant and refugee communities. At the same time, we also want to note that these are attacks on bedrock constitutional principles, and as such, they have implications for all Minnesotans, citizen and non-citizen alike. Thank you.
Ms. Nelson, did you want to add anything now or just here to answer questions?
Madam Chair, I am just here to answer questions. Thank you.
Thank you very much. Members, questions? Senator Dibble.
Thank you, Madam Chair. A question to whomever would like to respond. A lot of attention has been galvanized by images in the news and on social media of ICE and perhaps also Border Patrol agents bursting into people's homes and other private spaces without the benefit of a judicial warrant, surrounding homes with guns. Just a story yesterday about a house that was surrounded with guns pointed at it where only 2 children were home. But more importantly, crossing the threshold, entering private space when told explicitly they are not welcome to come in without the benefit of judicial warrant. And of course, we've heard about the leaked memo in which apparently attorneys within Department of Homeland Security have indicated that that agency, for whatever reason, is not subject to these Fourth Amendment constraints. And I was wondering if you could spend some time visiting with us about that idea, that analysis, and the experience of any of your clients with that regard.
Ms. Nelson?
Madam Chair, Senator Dibble, thank you for that question. I am going to preface this by saying that I am not the immigration law expert in our legal team. However, and I'm aware of the memo that you're referencing where the department believes that it has the legal authority to enter homes without a warrant. I will say 2 things. One, we disagree with that. The Fourth Amendment has always required a warrant, and there is no immigration law exception to that. Well, maybe I'll say 3 things. Number 2, those claims by the federal government will ultimately be tested in court. And number 3, we are working to document all of these situations. And it is not a claim, or it is not a specific fact pattern in the Hussein litigation. All of our clients in Hussein did not experience this kind of home invasion. However, we have heard the same stories you have, and there's a climate of fear right now. People are terrified and very afraid to come forward, to tell their stories, to be on record with those stories. And so we are, at this point, working to document what is happening. We firmly believe that this violates the Fourth Amendment, and we disagree with the federal government's assessment of the situation. My understanding is that they're relying on the existence of a final order of deportation for somebody in the home. Whether or not that actually exists is unclear, because we have seen multiple instances where they've gotten the home wrong, and there isn't a person who is subject to a final order of removal. So even that justification seems sketchy, seems thin. Thank you.
Senator Dibble, follow up?
No, thank you, Madam Chair. I appreciate the information.
Senator Rasmussen.
Thank you, Madam Chair. And this is for whoever the testifiers is best positioned to answer this question. One change that has happened at the federal level in terms of immigration enforcement law has been the passage of the Laken-Riley Act. And I know the ACLU was opposed to that bill passing. It had bipartisan support from Minnesota's congressional delegation and fairly wide bipartisan support when it was passed and signed into law. I was wondering if you could talk about why you oppose that bill and what impact it currently has on immigration enforcement in Minnesota.
Ms. Nelson.
Madam Chair, members, the ACLU did oppose that. You are correct. We opposed it because we were concerned about arbitrary detention. My colleague John mentioned the Fifth Amendment right to due process, and another aspect of the Fifth Amendment right to due process is the right to be free from arbitrary detention. And so the Supreme Court has recognized that the government can detain people based on civil immigration violations, but that detention has to be directly related to the government purpose. And so that requires an individualized determination. And what the Laken-Riley Act does is simply cuts off that individualized determination. And so throughout our history with immigration law, we have laws that balance the right to due process and eliminating the risk of erroneous deprivations. And so even in situations where federal law requires mandatory detention, the Supreme Court has said if that detention becomes unreasonably prolonged, people need to be released. And I'm not talking about people who are pretrial, right? Because if somebody who is accused of a crime goes through that criminal process first, and we have a criminal legal system, we have citizens who are accused of, convicted, sentenced, punished for heinous crimes, and when their sentence is done, they have a due process right to be released if they are not a danger to the community. And if they are a danger, then we have a civil detention process, a civil commitment process that can sometimes be used. And so our opposition to the Laken-Riley Act is that it is sort of a reflexive, mandatory detention, regardless of the individual circumstances.
Follow-up, Senator Rasmussen?
Thank you, Madam Chair, and thank you for the answer on that, for clarifying the ACLU's position on that bill. The ACLU also, back in 2014 and kind of throughout its history, has sued multiple administrations over immigration enforcement. And I'll just read, this is from the ACLU's website on a headline on a press release they put out. They said, ACLU sues Obama administration for detaining asylum seekers as intimidation tactics. And I know also the ACLU basically called President Obama the deporter-in-chief, and also, I believe, took the Obama administration to court for using administrative hearings versus, having detained illegal migrants go in front of a federal judge. And I was wondering, did you win any of those cases against the Obama administration? Did the courts find that they violated rights, and does that inform the conversation today that we're having on immigration enforcement?
Ms. Nelson.
Madam Chair, Senator, yes, thank you for bringing that up, because it demonstrates the fact that the ACLU is a nonpartisan organization, and we are here to fight for people's constitutional rights. And the answer is that, yes, we have won cases against the Obama administration. Again, I'm not the immigration law expert, but I want to say that Jennings v. Rodriguez was a case that was brought during the Obama administration. That's a U.S. Supreme Court decision. And there are a number of others. And I have been at the ACLU of Minnesota since 1997. And we have done a number of local immigration law litigation, and that has spanned administrations.
Senator Rasmussen?
Thank you, Madam Chair. Just one follow-up for the ACLU testifiers here today. If we have an individual who is here in the country illegally, they've committed a serious crime, are being held in a jail in Minnesota, and ICE requests to be notified of the release of that individual so that they can go safely apprehend them and enforce our nation's immigration laws. Is that something that local governments can do, and do you support having violent illegal migrants handed over to federal immigration authorities?
Ms. Nelson.
Madam Chair, Senator, I believe that you are talking about the ICE detainer request system. And I would say that under Minnesota law, local jails, when an individual is set to be released, let's say that a local court has set a bail amount and they are bailing out of jail, that means that the judge has said, okay, you can be released into the community if you meet these conditions. So that decision has already been made for that person to be released into the community if they meet those conditions. At that time, it is not unlawful for a jail to notify ICE that this person is going to be released. What is unlawful is for that jail to then hold the individual so that ICE can come to take custody for them. Once they have been released, the jail needs to treat that individual in the same way they treat everybody else, and process them in the ordinary course and release them. And if ICE has not arrived yet, they don't have the legal authority to hold somebody beyond that. There is a Minnesota Court of Appeals decision, Esparza versus Nobles County, that says that local law enforcement, when you are holding somebody beyond when they are supposed to be released under state law, that is a new arrest that does not have probable cause, it does not have a warrant, you do not have lawful authority, and that at that point violates our state constitution.
Senator Rasmussen.
Thank you, Madam Chair. Just one follow-up on that. If the local agency has an agreement with federal authorities to cooperate on federal immigration law, does that change their ability to honor holds and detainers?
Ms. Nelson.
Madam Chair, Senator, no, it does not. It does not alter the state of Minnesota law. And there's an Attorney General advisory opinion on that. The ACLU has filed litigation against a county for having such an agreement that would allow them to, or that purports to allow them to hold people beyond when they should be released from state custody. And if you look at the 287G statute, it does not alter state law. It requires consistency with state law, and our state law does not allow this kind of rearrest for civil immigration law.
Senator May-Quade.
Thank you, Madam Chair. This question can be for anybody, and I know, Terry, you've said, Ms. Nelson, you've said that you're not the immigration attorney. If somebody is in this country, they had their asylum interview at the border, they were admitted entrance, and they are pursuing their asylum case, and they have a work visa, are they undocumented?
Ms. Decker? Ms. Nelson?
Madam Chair, Senator, so a person who is in the process, who has been processed at the border and is proceeding with an asylum application in that sense, this is where the binary documented, undocumented distinction actually sort of falls apart. And this is one of the nuances of immigration law. A person in that process really does not fit in either of those categories, because they are on the pathway to potentially receiving what we would consider a documented status, but they haven't actually received what we would consider a fully lawful status. They are in the process. They are waiting for an interview or a court hearing at which that status will potentially be determined. Their eligibility is, going to be, they're going to go through that whole process. They're going to be asked lots of questions. And then there will be a decision by a decision maker, a U.S. Immigration Services officer or an immigration judge, to determine whether they receive that asylum status. So they have a work card, right? You mentioned the work visa is an employment authorization document that allows them to work. They exist sort of in an in-between status where they, are something in between. So, yeah.
Senator May-Quade.
Thank you, Madam Chair. Full disclosure, I did immigration casework for a member of Congress, so I did know that. I'm going to ask you a bunch of questions I already know the answer to, but I think we should kind of peel this onion. So if somebody has had their interview at the border, they've been processed, they have their work visa, they're in the asylum application process, are they known to the government? Do they have check-ins? Does the government know who they are?
Ms. Decker.
Madam Chair, Senator, yes, they are known at that point to the government. They oftentimes do have check-ins. They are required to update their address with the U.S. government.
Senator Mayquade.
Thank you, Madam Chair. For refugees who are vetted both in the country that they are either leaving or participating in refugee camp in before they come to the United States, and then they come to the United States and they are in the process of or have refugee status, are they here unlawfully?
Ms. Decker.
Madam Chair, Senator, no, they are not here unlawfully. Refugees have lawful status.
Senator Mayquade.
Thank you, Madam Chair. And I actually forgot in the last one, if somebody has been vetted at the border, has a work visa, is going through the asylum process, they've done the biometrics, all that, are they here in this country unlawfully?
Ms. Decker.
Madam Chair, Senator, I would say, again, that is a little bit of a nuanced question, but we would not say that that is unlawful in the sense that they are currently in a lawful process to try and obtain a lawful status.
Senator Mayquade.
Thank you, Madam Chair. I want to ask a little bit about DACA recipients, but I want to be really careful. DACA recipients who have been approved for DACA authorization, work authorization, are they present in this country and known to the government, or are they just unknown and no one knows who they are?
Ms. Decker.
Madam Chair, Senator, DACA recipients are known to the U.S. government.
Senator Mayquade.
Thank you. And could you just use the words DACA stands for?
Ms. Decker.
Madam Chair, Senator, DACA stands for Deferred Action for Childhood Arrivals.
Senator Mayquade.
Thank you, Madam Chair. So I guess my long point, and thank you for following me down this road, the Minnesotans who are in this country, who are asylum seekers, who are refugees, who are DACA recipients, they are Minnesotans, members of this community. They are lawfully present in this country. Just because they arrived here and weren't born here does not mean that they are unlawfully here. I hate the phrase illegal because no person is illegal, but these folks are specifically lawfully in this country. These are the moms, dads, grandparents, bus drivers, doctors, nurses, daycare directors, teachers. These are the people that are in our community every day. These are my neighbors and my friends. And so this insinuation that there is a swarm of people in this state unknown to the government, that the Minnesota lawmakers aren't cooperating with to do something with, that is how we got, that lie is how we got here. That misinformation is how we got here. I want to go to you because you said that 240-ish names have been published by, or 240-ish names have been confirmed on this like random number of several thousand people that they're here to get.
Mr. Bueller or Ms. Nelson?
Yes, thank you. I believe you're referring to the DHS claim of ICE individuals with ICE detainers. Is that correct, Senator? Yes. So that was a recent fact sheet published by our State Department of Corrections. DHS made a public claim that there were 1,360 individuals with ICE detainers in Minnesota custody. And the DOC did a survey. They have 207 individuals in state custody and another 97 in county custody. Where those 1,000 individuals are, discrepancy between the federal number and the state number remains to be seen. But given the accuracy of the state number, we are awaiting confirmation from the federal government on the remaining 1,000.
Senator Mayquade.
Thank you, Madam Chair. I want to give a lot of credit to our local media who has done extensive reporting on this. Star Tribune reported on this. Many, many names on this list are people who've never been in Minnesota. They've never been in Minnesota custody, have no criminal records, or have a driving infraction, and so at no point would have been in state custody and then would have been turned over to the federal government. That they're just people who haven't committed crimes, or some of them aren't even real. So if I'm looking at this number, 240 we'll say, that means that we have 16 and a half federal agents per person that they're looking for with ICE detainers who are currently in state or local custody. These people are currently incarcerated, so they're not living in our community. Is that right?
Mr. Bueller.
Thank you, Chair, Madam Chair, Senator. That's correct. They are in state or county custody.
Senator Mayquade.
Thank you, Madam Chair. My last question is about the sheer volume of violations. I've heard a lot of the stories that you shared. Some of them are new to me. And what stuck out to me was the ruses, the getting a call saying you have a box on your doorstep. There was a daycare worker in my community who was working, and someone came in and said, oh my gosh, it was a woman. There's been a car crash in the parking lot. We need your help. And she went outside and was detained for several hours by ICE before they figured out that she is in fact a U.S. citizen, and was returned terrified to the daycare. Can you talk more about these ruses? We've seen some rumors that are possibly real or not, but we've seen real ones. Can you just talk about the ones that you've documented or verified?